Well, thank you, Glenn, and welcome back. The early warning mechanisms in the NEC contracts are often cited as one of the NEC's unique selling points. It's one of the things that sets it apart from other standard forms of contract that do focus more on liabilities and risk. It is a key element of the NEC's proactive and collaborative approach to risk management. So that said, and bearing in mind the straightforward language that's used in the NEC, there should be a reasonably straightforward buy-in to these concepts by everybody concerned, and relatively little difficulty in applying the principles in practice. And whilst hopefully we'd agree that that is generally true, what I'd like to do for the next 10-15 minutes is just touch on some of the sticking points and issues which we come across when discussing these issues with our clients and which we've observed in the industry. Make the clicker work, good. So as we know, clause 16.1. It places an obligation on both the contractor and the project manager to each warn the other as soon as either becomes aware of any matter that could have an impact on the 4 listed points there on the slide that are listed in the clause. Those 4 points should be treated as the minimum of what should be the matters that should be notified. And that the fact that they are the minimum is supported by what clause 16.1 goes on to say, which is that in addition to this, the contractor may also give early warnings to the project manager of any other matter that could increase his total cost. And so one issue that language creates is whether this is a closed set. Is this all you can warn about? We've got our 4 mandatory matters that are listed, a discretion for the contractor to notify other matters that may increase his total cost. But in addition to that, may the contractor, for example, warn of another matter that might affect the project in some other way other than by increasing his own total cost? And in addition, can the PM warn of anything other than the 4 listed matters? The answer to that, both those questions, seems to be a straightforward yes, but it is interesting that neither of those scenarios are addressed in the drafting of the clause. But our advice to clients is that the answer is yes. So we look both at the language style of the NEC and the overarching principles in clause 10.1 to conclude that there's nothing in there that makes us take the view that we should treat the listed matters in clause 16.1 as being in any way a closed set. Now, having said that, move on from that one. There are some things more than others that are quite obviously going to fall within the category of things that should be notified. Things such as the ones on the slide are obviously things that you would raise an early warning about. But there's also probably a lot of other things, such as the things that are shown on this next slide, that probably at some point will also come within the 4 listed bullets, but they may not in all cases, or they may not have as yet. And so an approach that we sometimes see clients take is that parties agree to amend clause 16.1 via the dreaded Z clauses, so that the list of express mandatory matters is expanded, so that early warnings will also be given to include matters such as those listed there, matters that might adversely affect the employer or the work of others, might constitute a defect, cause a breach of contract or applicable law, and lead to default, termination or suspension. As I say, these are things that will probably all at some point come within those 4 listed bullets, but if the goal behind the early warning is to warn early, then perhaps this will give you guidance as to the sorts of additional things that you might want to warn about. Now, who gives the warnings? Well, traditionally it tends to be the contractor who issues the majority of the early warnings, because obviously he's the person on the ground, the one who's most closely associated with the work and most likely to identify issues first. But the PM should be equally motivated to give early warnings to maximise the time available to consider problems with the contractor and to find a solution that best meets the employer's needs. But one of the legal difficulties that can create is that in order to comply with the duty to warn and to comply with the contract ethos of acting in a spirit of mutual trust and cooperation, you may have to confess to having done something wrong. And it's interesting because the early warning process is intended to take away that let's keep quiet for now and see if we can fix it approach that can be prevalent in projects that are procured under other more traditional forms of contract. And the early warning process is not meant to be about apportioning blame. The process shouldn't concern itself with whose fault the problems are. There are, of course, other mechanisms in the contract for that. But if that's not understood or applied properly, then the point is that it makes it harder to achieve the potential benefits of the process. And so coming back for a moment to the issue of who gives the warning, and this is the concept of awareness, which is integral in Clause 16. So say there's a problem with the design. So if it's due, for example, to a subcontractor's failure to comply with its subcontract design obligations, and this could cause a delay to completion, then obviously that's going to need an early warning to be raised. And the contractor is most likely to be the first to be aware of this, and so he would warn. But what happens, though, if the contractor thinks that the cause of the problem lies in the design as provided in the works information by the employer? It's still a matter that could delay completion. But should he give the warning, or should he wait for the PM as the employer's man to do it? Well, Clause 16.1 requires that each give the other warning of any matter, not just the ones for which you're responsible for or might have come down to you as your fault, but you warn of any matter as soon as you become aware of it. So in that scenario, the cautious contractor would think the PM might not be aware of this yet, but I am, so I will give the warning. And the awareness integral in this clause appears to be subjective. It says you warn as soon as you become aware. It's not supported by objective language, although arguably some may choose to write that in as an amendment. But it's not supported by the objective language, for example, or as soon as you ought reasonably to have become aware. But query whether it is a purely subjective standard. We would say that there's likely to be an objective element involved in when and how and for what you should warn. And that follows from the wording in Clause 61.5. So crossing over into the CE section. Because this clause, which is on the slide, permits the PM to decide that the contractor has failed to give a warning that an experienced contractor could have given. There are consequences for that. So I think we can all agree that it's in the contractor's interests to give early warning notices so as to avoid the possibility of a decision being made by the PM under that clause, that he should have but did not give such a warning. So there's a consequence clearly set out in the contract for the contractor's failure to do so. But equally, as I've said before, it's in the PM's interests to raise matters as soon as he becomes aware of any matters so that he can manage the situation to the best of his abilities as well to avoid cost and or delay. But the contract doesn't contain an equivalent to Clause 61.5 acting against the PM. So what happens if he didn't give a warning that he could have given? We'd say that there's probably an equivalent obligation implicit in the contract or derived via Clause 10.1 obligations, so that a failure by the PM to give a warning that an experienced PM would have given could be a breach of contract, could give rise to a CE, although I would also say it's fair to say that could be a difficult argument for a contractor to run successfully, and it's certainly not been tested by the courts yet. But back to the contractor's position regarding sanctions for not giving an early warning. Now, bearing in mind, of course, that not all early warnings will ultimately lead to CEs, but for the ones that do, then there's a cost sanction as set out in Clause 63.5 for a failure to warn. And it's interesting to note that the notification I just mentioned in Clause 61.5 acts as effectively as a precondition for the sanction to bite. Because if you look at the opening words in Clause 63.5, if the project manager has notified the contractor of his decision, we're talking there about the decision under 61.5. So if he's given that notification, then the CE will be assessed as if the contractor had given the early warning. Now, this again is slightly ambiguous wording, but it's, I think we'd all agree, unlikely to mean let's just pretend the contractor gave his warning and we all carry on. But the more commonly accepted interpretation of the wording is that it enables the PM to consider the mitigation measures that could have been taken but haven't been taken as a result of the failure to give the early warning. So what would or could we have done if we'd known about this problem earlier? And under all of the main options, other than F, a CE is valued then as if the contractor had given the early warning, which means that any change in defined cost or the effects on planned completion which arise due to the contractor not giving an early warning will be discounted when assessing the resulting CE. And in addition, under main options C, D and E, any cost the contractor has incurred because he failed to give the early warning will be disallowed costs. So very, very briefly, that's the main thing that the contractor needs to be aware of, is potential cost sanctions for a failure to give the early warning. But what else can create issues or stop the process working as intended? And I've used the word process several times, and that's because, leaving aside the CE side of things, it really is a process. You've got 4 stages involved with the early warning mechanism. You notify the early warning. You set up a risk reduction meeting if that's required. You work together to agree action plans and try and get the best outcome. And then you update the risk register as required. And whilst that's a straightforward process, we often see that people, and not necessarily just those that are new to the NEC, struggle to implement it properly. And sometimes, admittedly, this is because of the cultural shift involved when new users are moving away from the more traditional procurement routes they're familiar with. But in addition to that, other key points we see that are worth bearing in mind are the importance of education. In particular, ensuring that there's a genuine awareness within the team before the project starts about how the process works. And that is a point that is particularly useful when supply chain parties are new to the NEC. And part of that should include a buy-in to the concept that early warnings are not adversarial tools and risk reduction meetings are not a blame game or finger-pointing exercise. Part of the challenge we see here can often be working against the assumptions that new users may bring about the enormous administrative burden that they're expecting to be lumbered by when they engage in NEC for the first time, and explaining to them that, take a deep breath and it's not actually as bad as they may think. Supply chain consistency is another issue we see. So the early warning and risk reduction processes work best if the NEC suite is used right along the supply chain, and Rob's shown us the way that can all work together. And if it's not, if we're not using the same suite of contracts, making sure that bespoke amendments are nevertheless made to the other forms that might be in use to ensure that there is a buy-in to the early warning process throughout that supply chain. Because otherwise, there's little point if an employer and a contractor with their PM are trying to use the risk reduction process if none of the suppliers and subcontractors are doing it as well, because how will we know of the problems that are brewing below us? And the greater the extent of subcontracting, obviously the bigger the issue that would create. Also important early on can be setting up a list of the type of things for that particular project which the group think are likely to be the things that are going to come up and require early warnings, creating within people who are new to it a familiarity with the types of things we would expect early warnings to be raised on, going back to those points earlier. And then also drawing a distinction and really reinforcing that that might be a different list to what is going to be a compensation event list, because that happens later. And that brings out the point about the importance of training people in what an early warning is not. It's not a compensation event. The notification of an early warning is not the notification of a CE. And if you think you're doing those two things at the same time, then you do have problems. So clearly the circumstances and the timing of those two things should be very different. Very different. And the next step then is how to manage these early warnings when raised through the risk reduction meeting process. Again, the language in the contract is quite straightforward as to what you need to do. Clause 16.2 authorises both the PM and the contractor to call a risk reduction meeting at any time. That's a good thing. And although the clause provides that either of them can instruct the other to attend, the consequence of not attending is not addressed. In other forms of contract, you would probably have that all set out. But one of the joys of NEC is that it's assumed that you don't need to say that there's a consequence because everyone will want to engage. But one issue to consider is the fact that the language, the use of the word instructing others to attend as well can be problematic, because the effectiveness of that depends on the PM or contractor having it within their power to so instruct. So clearly that mechanism works best in relation to subcontractors, where the contractor can instruct them to attend. The employer will hopefully choose to attend voluntarily. But to the extent third parties are involved, that can be more difficult to get them to the table. And bear in mind also, of course, the supervisor has no automatic right to attend risk reduction meetings, but must be invited, so don't forget to invite them. There's also then Rob's minimalist document to bear in mind, the risk register itself. And we need to ensure that there's an understanding of the need to translate those early warnings into risk register matters and to actively update that risk register to record the decisions that are made at risk reduction meetings. This is essential, as otherwise the risk register cannot be the active risk management tool it's intended to be, but rather becomes a static risk allocation summary or a document that doesn't ever evolve beyond the original listing of risk register matters that might have been set out in the contract data. And that, I think, highlights that a potential means by which the role of the risk register can be undermined is via a lack of understanding of the difference between the risk register as a document and the contractual risk allocations, which can bring with it a mistaken impression that the contractual allocation of risk can be set by or in some way altered via the risk register. Now, the risk register only requires two pieces of information: a description of the risk and the steps which are agreed to be taken to deal with that. It doesn't require any consideration of who owns the risk. That's the job of clause 80.1 and the associated contract data entries. And it shouldn't seek to alter that ownership of risk, although it is often sometimes used as a tool for that purpose. It doesn't require any value to be placed on the risk. And again, it is unfortunately sometimes used as a tool or a placeholder to inform the employer of what you're expecting to get when we get to the CE stage of the process. But from a purist point of view, these are not things that should go into the risk register at all. Touched on details of the early warning process, touched on the linkages to the CE provisions. I'm not going to overlap with what John's saying, but they are two of the three core stimuli within the NEC for proactive risk management, and the other, of course, are the programme provisions. Two simple points to make there really are that the list in clause 31.2 of what every programme should show, although can strike horror into new users, we would see as a list of the minimum things it can be added to. Query whether you would want to perhaps show early warnings on those programmes, early warnings of matters that are yet to be resolved, and link that, perhaps harking back to the language that was used in the NEC3 which was taken out, about the revisions to the programmes, also showing the effects of decisions reached in early warning, in risk reduction meetings. So whilst 32.1 already provides for the effect of implemented compensation events to be shown, what about those things that got resolved before they got to that stage? There could be merit, if used well, for perhaps showing those as well. One last thought. I won't go into the differences with FIDIC, other than to say it is interesting that, unlike the NEC, the FIDIC programming provisions that also do deal with the showing of these sort of events link into the time bar provisions in clause 20.1 of the FIDIC contracts. We don't do that, and it's just a last point to make on that, I think, is that some of us may experience that contractors typically devote more time and effort to engaging and fulfilling the requirements under the CE process than perhaps they do under the early warning process. And there may be many reasons for that, and that may not be true in all cases. But it is interesting, and not something I'm in any way suggesting should be different, but query whether that, to the extent it is true, has something to do with the different sanctions that are involved. So if you fail to notify a CE in time under 61.3, then you risk your claim being time barred. Whereas the sanction that we've mentioned before under clause 63.5 regarding early warnings is certainly less draconian. The consequences of a failure to warn are harder to quantify. And so therefore it's more of a grey area as to what the PM can actually do to you if you do fail to warn. Although, as I say, I'm emphasising that we should not treat that as either a reason to add a time bar or either a reason for contractors to ignore the process as being something they should do anything other than engage in fully. But it is interesting that we do have that different approach. And as I say, contrasted to the more traditionally adversarial approach taken in contracts such as FIDIC that do have linkages that we don't have to their time bar clauses. So none of this is really difficult stuff, but a few conclusions before I hand over to John would be that we should see and encourage people to see early warnings as a sign of a well-run contract, a healthy contract. Point being that if we don't have many early warnings being raised, then we'd like to think that that means everything's running smoothly, but it is more likely to mean that problems are being stored up for later. We should give priority to problem mitigation and deal with contractual liability as a secondary issue, a next step in the process rather than something that should prevent this initial stage being managed well and to the best of its capacity, effectively. We should keep early warnings and compensation events separate, but understand the linkages between the two and how one can affect the other. We should also bear in mind that a lack of agreed deadlines and programme dates, so not really fulfilling the opportunities that the programming provisions provide, make it difficult to judge whether an early warning is required. And to understand also that early warnings are part of a process, as I say, a process that runs through from the giving of the initial notification and asking yourself that question of, should I just raise this now for the abundance of caution? Is there a reason why I shouldn't? In some contracts there might be a reason because I don't want to put my hand up, but this is a different contract. So a process that starts from that thought process runs through the meeting process, risk register updating, programme provisions, and then ultimately potentially through to the CE process. Managing that well and understanding that you've got a continuum of events is one of the keys to managing and maximising the benefits of the process. But then sometimes it doesn't all go well. I'll hand over to you.